Welcome once again to Lehto's Law. Here's Steve Lehto.
Grant sent me a story, said, Steve, check this out. It's out of West Virginia. And it involves evidence not being admissible in court and a pattern of a problem. So a federal judge seeks review of cases over evidence concerns. Reuters published it. Mike Scarcella wrote it. The federal judge asked the new U.S. attorney in Charleston, West Virginia, to review what the court described as an unusual number of judicial decisions in recent years that said evidence was seized unlawfully and can't be used at trial. So trials have happened. Judges have ruled that evidence cannot be used, and it's happening more than it should. So what's going on there? West Virginia U.S. District Judge Joseph Goodwin's ruling came last month, and it criticized law enforcement and the prosecutor's conduct in a drug case in which the judge found, a search violated a man's rights. At the same time, he suggested that the U.S. attorney conduct a review of recent suppression rulings, which the judge called an area of concern. Because you have to understand, if you go to trial and the prosecution thinks they have evidence against you, and your attorney gets that evidence suppressed because it was taken unlawfully, for instance, well, that's good for you because they can't use it against you. But it raises the question of, well, why did they grab it unlawfully? Aren't there ways that they can do that lawfully? And if so, why didn't they do that? So if it happens more often, then it makes you wonder what's going on. The judge rejected a request from the U.S. Attorney's Office to rescind an earlier finding that a detective made statements in reckless disregard of the truth. The judge has served on the trial bench since 1995, used the ruling to address protecting the integrity of our criminal justice system. Federal prosecutors, the judge wrote, are taught that the prosecutor's role transcends the role of adversary. We've talked about this before. The U.S. legal system is adversarial, meaning that when you go to court, the pleadings against you will be case captioned. At the very, very top, the first thing is going to say state of such and such versus you, the city of such and such versus you, whatever, or the people of. And then, if you're in lawsuits, it's you versus them. That's a lawsuit. So adversarial system. So a lot of times, defense attorneys think, well, it's my job to defend my client as best I can. You go, that makes sense. Prosecutors often think, well, it's my job to prosecute and get convictions. No, it's not. It's not your job. That's why they say here that the prosecutor's role transcends the role of adversary. They're not merely an adversary. It's not their only goal to win. They've got to represent the people, but they've got to do it in a way that follows constitutional guidelines. The judge wrote, when prosecutors overlook, tolerate, or fail to intervene in the constitutional failures of law enforcement, they abdicate the responsibilities imbued by their oaths of office. He deferred to the West Virginia state judge to review the number of suppression motions that have been granted in this district in the past 2 years. A spokesperson for the Charleston U.S. Attorney's Office declined to comment on Tuesday. A prosecutor assigned to the case did not return a message seeking comment. The judge, through his chambers, also declined to comment. In December, the judge issued an order suppressing evidence seized from a house in 2021. The judge questioned the accuracy of certain statements made by law enforcement in an affidavit to get the search warrant for the house. The government has since filed a new indictment. After the judge issued the suppression order, the U.S. Attorney's Office sent 2 investigators to interview the state magistrate judge who issued the search warrant. And the judge here said it was improper for investigators to seek such an interview and for the judge to even entertain it. This judge wrote, it is inherently intimidating to send federal officers to question a state magistrate judge, and it is clearly out of bounds for the magistrate judge to provide the interview regarding his judicial decision-making in a matter pending before this court. A trial in the case is scheduled for May, and so this is all coming from one case, the United States versus Lark out of the Southern District of West Virginia. But it gets back to what a prosecutor should do when they encounter questionable evidence. And so if you think about how this works, the police are doing an investigation. I'm just going to go with a generic set of facts here. The police are conducting an investigation, and they develop probable cause that they believe shows that there's going to be something, evidence in the house, that if they had a warrant, they could get in there and get this evidence, and they've got probable cause to show that. So they write up an affidavit, an application for a warrant. And they say, we want to search this house for, and they'll identify what they're searching for. And then they'll say why they believe they've got the probable cause to get the warrant. And they'll lay out all the facts. On this date, we saw somebody go in carrying contraband. They came out without it. Next day, someone else went in carrying contraband. They came out without it. Later on, we saw people approach the house, and later on, they came out carrying contraband. So, this is all evidence to indicate that this stuff is going into the house and going out, and it's being, and they'll lay out these facts. And I've read these affidavits before, and they can be very, very lengthy and very, very detailed. But a lot of it is based on observations by police officers. And a police officer will sign it and swear to it under oath that all of these statements are true. All of these things are true. And so if you're involved in a criminal defense of one of these matters and you're going through all the evidence, you examine the affidavits that were used to get the warrants. And if you go through there and you see stuff that, like, what? And you'd be amazed. So I mentioned before, and I just happen to have it sitting here, Drawn to Injustice, the book that I co-wrote with Timothy Masters, who spent 10 years in prison for a murder he did not commit. I saw the affidavit that was used to get the warrant to arrest him, the arrest warrant. And that's very similar in the sense that an officer writes out all of these allegations that he thinks tend to show that someone committed a crime. And they go to a judge and say, this is what we've got here. And that affidavit is filled with nonsense. And that's part of the problem here. While the trial is adversarial, the process leading up to it is not. So that someone can fill out an affidavit and sign it and give it to a judge who looks at it and goes, oh, okay. And the judge signs it and then issues the warrant. And it's the same way that we talked before about how grand juries, the joke is they could indict a ham sandwich because the process is not adversarial. That is that someone gets in front of the grand jury and starts putting in evidence and presenting evidence and goes, here, that's all the evidence we have. Will you issue an indictment? And the jury, with all the evidence in front of them and nobody defending anything, goes, oh, it looks to us like there may have been a crime committed. It may have been committed by this guy. And if the probabilities are better than not on both those, an indictment gets issued. And of course, it goes to trial and it falls apart because there's no evidence beyond that. But it's not the point. The point is that it becomes adversarial once you're in court. But all of the people in that system preceding the trial have to remember that they've got a job that is not always adversarial. So that when a police officer or somebody signs an affidavit that's going to be used to get a warrant, somebody should review it and go, is this proper? Is this fair? Is this honest? And if it is, they present it to the judge. I don't blame the judges for signing the warrants or issuing the warrants after they've been presented with an affidavit because they assume, well, it's sworn, it must be accurate. But if a prosecutor encounters something and they realize, wait a second, this stuff was, acquired because of a search warrant. The search warrant was issued because of a bad affidavit. Well, then they've got issues. So the judge wants to remind the prosecutors, your job is not entirely adversarial. It's not. And if there is a pattern of stuff in a certain area that warrants get issued and later on the stuff gets suppressed because the warrants are bad, if that happens more often than in other places, someone needs to take a look at that. And that could be a problem somewhere in the system, like I said, preceding trial. It could be the work of detectives. It could be the work of a prosecutor. But someone needs to investigate that and get into that. So that's what the judge is asking for. He's asking for them to take a look at that and figure out what's going on. So Grant, thanks for sending me the story. Mike Scarcella wrote it for Reuters, and a federal judge in West Virginia seeks review of cases over concerns with evidence. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. All generalizations are false, including this one.